Good afternoon or good morning, good evening, wherever you are in the world. Welcome to this wonderful webinar being hosted by the TradeLab community, entitled Tariff Wars and WTO Law, Addressing Protectionism and Retaliatory Measures. I want to, on behalf of myself and Catherine Coleman, co-presidents of the TradeLab Group, to welcome you all. TradeLab is a consortium of universities hailing from basically all over the world, where we use legal clinics with students that we supervise as a pedagogical tool for teaching more about international trade and investment law. Members of the TradeLab group come from all over all continents. We are supervisors, many of us on this webinar are supervisors of students who we supervise, and as part of the community, we entertain also mentors who assist the students in assisting beneficiary clients, and these can be states, they can be NGOs, they can be any community, particularly from the developing world, that needs assistance in a matter arising under international economic law. And so, just like any other legal clinic, we supervise them, and at the end of the time period, which is quite short, we produce a finished product that they act as legal counsel to advise the beneficiaries on the specific topic of international economic law. And this TradeLab was founded many years ago by Jos Paulin and Sergio Puig, and it has evolved over the years. And right now, I'm really proud with Catherine to be the president, and we are assisted by an executive committee and a general assembly constituted by all of the supervisors of the TradeLab community. This is the first event that we are kind of opening the doors. Some of the speakers are supervisors, and one is a student, to talk on a topic of international economic law. And I'm really proud that TradeLab is doing this, and we're hoping that it provides great food for thought. I want to thank very much Saloni Shukla, our TradeLab coordinator, who has made it possible. And I will hand over to our moderator, who is from the University of Sao Paulo, one of our supervisors again, Luiz Eduardo Salles, who will introduce the other speakers on the panel and give you more information about how this program today, this webinar will run. So again, on behalf of Catherine Coleman and myself, welcome to this session, and we hope you find it fulfilling, and we hope you find that there's lots of opportunities for discussion. Over to you, Luis, and thanks again, everyone.
Thank you so much, Ms. President Genevieve Remy. So as we've heard, the topic of this webinar is Tariff Wars and WTO Law, Addressing Protectionism and Retaliatory Measures. During this next hour and a quarter of an hour, we will discuss the interaction between WTO rules and current tariff increases. As maybe you will agree, the relationship between domestic trade policy and the WTO has never been an extremely easy one. Yet, in these present days, I think this almost inevitable tension between these two dimensions, the multilateral trading system and the domestic dimension, has made it to the spotlight. I think it's not so huge of an exaggeration to say that the multilateral trading system as we knew it may be facing kind of an existential threat with what's happening today. And plus, I don't know about you, but the speed and intensity at which tariffs have been imposed, withdrawn, and discussed these days has been a bit overwhelming, and at least to me, sometimes very, very confusing. So I therefore am very glad to have you all here and to welcome our incredible panel that will discuss tariff wars and WTO law today. In moderating this session, I will have the company of Alvin Kubasu, graduate of Kenyatta University School of Law, currently undertaking an advocate training program at the Kenya School of Law. Alvin Kubasu is part of the TradeLab students researching the impact of stay of applications on common external tariffs. So one more very interesting topic that our students usually entertain in our projects. And then, of course, we have our stellar panelists. So we have Professor Edna Ramirez-Robles. She is the Dean at the Faculty of Law and the Professor at the University of Guadalajara, Campus Puerto Vallarta. She has 25 years of experience consulting for more than 58 countries, having worked with more than 20 national trade facilitation committees, and at UNCTAD, the WTO, and the IDB secretariats, and also on technical assistance projects funded by multiple international agencies. So thank you so much for being here, Professor Ramirez-Robles today. And we further have Professor Nicolas Lamp, an associate professor at the Faculty of Law at Queen's University in Canada. Professor Lamp is also cross-appointed to the School of Policy Studies at Queen's and serves as director of the Queen's Annual Institute on Trade Policy, which is a professional training course for Canadian trade officials. Dr. Lamp has worked at the Appellate Body Secretariat, and his 2021 co-authored book with Anthea Roberts, titled Six Faces of Globalization: Who Wins, Who Loses, and Why It Matters, highly recommended reading, published by Harvard University Press, was selected as one of the best books of that year, 2021, by the Financial Times and Fortune magazine. So with thanks to our speakers, just some housekeeping before we start. We have, as I said, maybe one hour and a few minutes, maybe almost half an hour during the, let's say, 50 minutes or so, first 50 minutes or so. If you have a pressing question, you may use the chat function. After that time, we will have some time, hopefully, for a Q&A, where everybody will be able to raise questions through the chat function, or maybe orally, if we manage the tech. So with that housekeeping, let us begin. As you've heard our co-president, Jean-Yves Remy, at the beginning, TradeLab is very much a student-centered association or consortium. So I heard that loud and clear. With that, I think we should ask Alvin Kubasu maybe to start here. Alvin, what would you like to hear from our speakers?
Thank you so much, Luiz, and thank you to all the participants. Good morning, good afternoon, and good evening from wherever you are joining us from. To our esteemed panelists, that is Professor Nicolas and Professor Ramirez, I think I have three particular questions in which you can choose how to go about it. The first one is, over the course of the onset of this, the trade wars, the question that countries have always asked is, where do we draw the distinction between the country's right to legislate at the same time to adhere to their WTO obligations? And so maybe you can shed light on how best should countries go about this when they are legislating, at the same time to avoid during this legislation process to violate the WTO rules. The second question is, even when you're talking about these trade wars, I mean, it's good that the scholars in this sphere are proactive in terms of discussing these issues. But then the question remains, how about the political players? How do we involve them? How do we engage them? Because when all is said and done, these are all political moves, and then the political players are the ones who we can actually say they have the final say. So how do we involve them? And lastly, on that, as we kickstart this conversation, is we are at a place where we are favoring more of bilateral agreements, economic partnership agreements at the cost of globalization. So what's your general take about that? Is the multilateral trade system in jeopardy, and how do we take it back to where it was supposed to be? And even as we address that, how do we also ensure that we don't jeopardize the global value chains? So thank you. I think that's a good place to start.
Alvin, you started with all the easy questions.
It's always good to start easy.
Yeah, excellent. So let's hear from them. Maybe if you, I don't know if maybe you can go one by one, and we, right?
Okay.
Can you start with the first one, then we move to the others?
Sure. No. So the first one was on the legislation versus adherence to WTO law. So where do we draw the nexus, and how best can countries go about it?
Thank you. So maybe we start there. How can countries establish a balance between their international obligations and domestic kind of constituency and policy questions? I don't know if Professor Lamp or Professor Ramirez-Robles would like to start.
I'm happy to start. I mean, the question you ask goes to the heart of international trade law, right? We're always concerned with the balance between international constraints and domestic policy space, so to speak. But what we have to keep in mind is that WTO law gives countries a lot of space to pursue legitimate policy objectives. This is particularly the case in the case of developing countries. Many developing countries have very high tariff bindings, so they could even increase tariffs on a non-discriminatory basis without violating WTO law. The situation is a bit different for developed countries, and we're going to get to that later in the session. But even if countries feel the need to pursue certain policy objectives, such environmental objectives or health objectives, in a way that may seem to violate WTO law, there are always exceptions in the WTO agreements, for example, in the GATT Article 20. And so these exceptions can allow countries to violate, for example, a non-discrimination obligation or the prohibition of quantitative restrictions, as long as the countries do so for the pursuit of a legitimate policy objective, and they also do it in an even-handed manner, right? So Article 20 allows you to pursue a whole range of policy objectives, and we've seen WTO members being very successful in invoking that exception. Where they have run into trouble sometimes is under the so-called chapeau of Article 20, which disciplines the way in which you pursue that objective. But even there, countries have been able to adjust their measures and change their measures so that they would be able to pursue their objectives. So in general, I would say that especially compared to the GATT days in the 80s and 90s, the WTO jurisprudence has found a very good balance between allowing members to pursue their objectives while still safeguarding other countries' interests in international trade.
Yes, if I may proceed. So yeah, I agree with what Nicolas just said. First of all, thank you so much for inviting us and for organizing this lovely event. One of the things that are like obviously what Nicolas mentioned, it is the key, the core of the system, and there are also other type of flexibilities that exist in the system to provide precisely this type of balance. For example, there is like this constructive ambiguity has been called when they legislate, okay, when countries agreed on different clauses, okay? And there are many examples, and you see it across the WTO agreements, for example, at the GATS, at the services agreements, when they allow countries to keep negotiating throughout the years and not establishing like clauses that are clear-cut, or that they have strong elements to bind the countries, right? So where they allow countries to keep regulating at a national level. So this is one example, but they're like throughout through the TRIPS agreement, like there are tons of flexibilities in addition of those provided or mentioned to the by Nicolas mentioning this exception nature, and there is this other type of flexibility, right? Like the one that allows countries to regulate at a national level. There are many clauses that are called like best endeavor as well. Like for example, in this trade facilitation agreement that exists, that the countries can comply with the agreement to the extent of their capabilities, okay, or to the extent of their funds. So it's like you will see it like throughout every agreement that exists, this type of flexibilities. So this is another way of legislating. What is not allowed is to actually, now that we're talking about these wars and the tariff wars, is to take unilateral measures, right? And this takes us to the core of this of the subject of this seminar. So the whole point is like there are many ways where you can I don't want to say circumvent, but you can have and use your policy space, but comply with the international agreements and the international organizations, international obligations, right? However, this is not the scenario that we have faced lately. So this is what I can mention. Thank you.
So maybe just to drill down a little bit more on Alvin's first question, I think Professor Ramirez-Robles, towards the end of your reaction, you mentioned specifically the kind of the tariff scene, so to speak. If we focus on the tariff framework and domestic tariff measures, could you address what substantive rules there are that would discipline unilateral tariff measures?
Absolutely. I mean, the principles are very clear when we say, when we talk about disciplining in terms of prohibiting, okay, these unilateral measures. So it's the principles of the WTO. We all know them. The most favored nation, the national treatment, to respect the list of concessions, and to prohibit the quantitative restrictions, right? So this is in terms of forbidding and not allowing these unilateral measures. But also there is a way of allowing this retaliatory measures, right? And this is where you will see what Nicolas said at the beginning, okay? These exceptions that exist that are contained in Article 20 or Article 21 that now we see it like that is getting very popular, that talks about national security, right? So this national security issue is what has become the latest and the most modern way of not complying with and of justifying the not complying these principles that I just mentioned at the beginning, right? So this is something that is, if we go back, I mean, when we say that the system allows these exceptions, is because they allow the exceptions, but countries or members need to comply with certain elements, right? So these elements need to come together after a procedure, right? So it's not that it appears just from one day to the other, right? An executive order saying, oh, we're going to issue a unilateral measure. You need to pass through a procedure. And once that this procedure has finished, after, I mean, legally speaking, it's been the system that is always one of the, and we will get to that, to the type of rigid norms that have been established, that it takes about a year, let's put it this way, in the legal framework, but in the reality, it needs like no less than 2 years, like for on how the complex, because of the complexity of the cases, right? So it takes a lot of time to arrive to this last stage, that is the suspension of concessions. And the suspension of concessions is what is called, like, what is known as the retaliatory measures, right? And this is only when it's allowed, and after spending so many years and so many procedures. It's not only the consultations phase and the panel phase, but also the phase of a compliance proceeding, a 21.5 proceeding, then also a 21.3 proceeding, and also obviously the 22.6 proceeding. So these are the things that need to exist to actually allow a retaliation measure in the, or to allow a member to take a retaliatory measure. Thank you.
Just to add maybe a bit of nuance, if I can. So I think the obligations that are most at play in the case of the US tariff measures are Article 1, the most favored nation obligation, and Article 2, which is entitled Schedules of Concessions, and of course embodies the principle that no WTO member can raise tariffs above the bound level, and the bound level for each good is specified in the schedule. And so I think we have to be careful in saying that members cannot unilaterally raise their tariffs. They can absolutely unilaterally raise their tariffs as long as they stay within the bound level, and as long as they apply the same tariffs to all other WTO members. Just to give you one example, Mexico, until a few years ago, I think, had a 0% tariff on cars, which it simply decided to implement. And then it decided to raise it to, I think it was 20%, and it was allowed to do so because its tariff binding for cars was at 20%. So we have to be careful in looking at tariff increases, not to simply jump to the conclusion that any tariff increase is a violation of WTO law. We actually have to go look at the product at issue. Then you have to find the product of that issue in the schedule of the WTO member and look what the binding for that particular product is. And only if the new tariff that has been increased exceeds that binding, do you actually have a violation of Article 2 of the GATT 1994. And so the problem for developed countries like the United States is that many tariffs are bound at a very low level, right? So if you went to a developing country like India, India could implement the tariffs that the United States has implemented entirely legally because it has very high tariff bindings, right? It could raise its tariffs on steel and aluminum to 25%. In fact, that's probably the tariff that it has approximately, without any problems. The problem for the United States is that its bindings are very low. And so when the United States implements a 25% tariff or a 50% tariff, it almost inevitably violates its WTO bindings and therefore acts inconsistently with Article 2 of the GATT 1994. The next question we have to ask is on who is affected by these tariff increases. So the United States has implemented two types of tariff increases, which are violations of Article 2, but not violations of Article 1, arguably. For example, it has implemented 25% tariffs on cars, or 25%, initially 25%, then later 50% tariffs on steel and aluminum. But they are applicable to virtually all import countries from which the United States imports these products. So while they are violations of Article 2 of the GATT 1994, they're not violations of Article 1 of the GATT because they're implied on an MFN basis. The other tariff to mention here is the 10% kind of universal minimum tariff that the United States has implemented under the heading of reciprocal tariffs. Again, this is a tariff that is now faced by all US trading partners, and so we don't have a violation of Article 1. So that's I think in the context of US tariff measures, we have to pay particular attention to Article 2 and Article 1, and we identify the violations there. When we turn then to the retaliatory tariffs that are implemented by some other countries like China or Canada as well, those face the same issues. They are also violations of Article 2 in many cases. also violations of Article 1 because they're only implemented vis-a-vis the United States. But they're also a violation of another provision, which Edna mentioned in passing, which is Article 3 of the Dispute Settlement 23 of the Dispute Settlement Understanding, which forces WTO members to resolve any disputes over violations of WTO obligations through the recourse to the dispute settlement procedures of the World Trade Organization. And by implementing retaliatory tariffs without going through the dispute settlement procedures, Canada and China are arguably also in violation of Article 23 of the DSU, because they're essentially taking justice into their own hands. And that has been a feature of kind of the trade wars triggered by the Trump administration, is that other WTO members have not had the patience to go through the WTO dispute settlement system, but have instead decided to retaliate unilaterally.
I think that's kind of a very nice ending to, I think, Alvin's kind of first question, going to, I think, your second question, Alvin, right? Which was like, how do you get politicians involved, or politicians to listen to what the rules would say, so to speak, right? Which I think was your second question. We heard Professor Lamp, Professor Ramirez-Robles say the word violation several times. So it's almost like if we came from another planet and we looked at the trade scene of today, it feels like one would not quickly realize that there is this relatively sophisticated system you mentioned, right, with all those rules in place, simply because, as Professor Lamp put it, I like that a lot, countries have not had the patience to kind of go through the rules in the system. So when we get to the way the system, I mean, has worked or not worked, I think the question that Alvin put is, to what extent do WTO rules actually shape or have shaped actual policy responses? And if they haven't, how could we think about having these rules kind of discipline state or politicians' behavior better, right?
So should I go first, Edna, or do you want to go first? Okay. So I do think they're not shaping the US response, because the US is essentially done with the WTO. I think we have to recognize that. For the United States, the WTO has failed in several respects. It has failed to discipline China. It has failed to discipline China's rise. It has failed to serve as a forum for negotiations to rebalance tariff levels between developed countries and the emerging economies, which was one of the objectives that the United States was pursuing in the Doha round of negotiations. And it has also failed because its appellate body has interpreted the rules in a way that the US thought was never agreed to. And so it has kind of gone off the rails. And so we have to, I think, give the United States credit that it was very engaged for decades. It was very engaged in litigation, very engaged in negotiation, trying to get the WTO, or rather the other WTO members, to correct course. And at this point, I think the bipartisan sentiment in the United States is essentially that it has given up on the WTO. That does not render the WTO irrelevant, though, because it can still shape the responses by other WTO members to the United States. And I think we have to make a categorical distinction here between the responses that they adopt towards the United States and the way they behave towards each other. There's, for example, a lot of concern now in Geneva, from what I hear, that members will try to appease the United States by somehow giving the United States preferential access to their markets, which would be, of course, a violation of the MFN obligation towards other WTO members, right? And so what we see now is that members are using the WTO as a way to influence the responses by other members, not so much the United States, because I think countries realize the US is not really receptive to those arguments, but they're trying to shape the reactions of other members so that other members stick to WTO rules when it comes to the relationship with each other. We also see some countries like the European Union trying to go to great lengths to say that they're still acting consistently with WTO law. So, for example, the European Union has this trick where they say we interpret the US tariffs as a safeguard, and under the safeguards agreement, we are then entitled to rebalancing, which is something that that neither the US believes is plausible. I don't think it's plausible either, but it shows an almost excessive attempt to try to stick to the WTO rules. But it does play a role, and I think most other members realize that what the United States is offering is not an alternative to international trade law, right? Because what the United States is offering is essentially a world of uncertainty. It's offering a world of unpredictability. And even the United States is experiencing that that's very bad for business. Like traders don't like uncertainty. Like even the oil industry in the United States, oil and gas industry in the US is horrified because there's so much uncertainty, they don't know what's going to happen, and it's bad for business. So it's not like the Trump administration is proposing an alternative model to international trade law that we could all kind of defect to. It is offering something that just doesn't work for the vast majority of countries. And so in a way, in a paradoxical way, I think it has reinforced the value of having rules, because rules provide certainty. And even though we can't have that certainty now in our relationship with the United States, we can still have it in the relationship among other WTO members. And I think that is something that we need to emphasize if we talk to politicians, that yes, in the United States, WTO rules don't have any traction anymore, but they can still stabilize the trading environment among other countries and therefore provide certainty to businesses, which they really are craving.
Yes, I agree with Nicolas. In addition of what he just said, I think it's also important to bear in mind that the WTO is still like the only forum where countries that do not have a free trade agreement signed, they have like this consistency and this predictability that Nicolas is talking about, right? About the bound tariffs, that at least there is a forum that exists, something that is agreed between countries, and that also provides, of course, a dispute settlement system, right? Like we can see the race of cases that China and U.S. have highlighted, and of course, we know that the big paralysis of the appellate body has been something that has that hasn't helped the system and this predictability indeed, but still there is a space where they can show their concerns, and countries and members can keep showing when there is an alleged violation of these different obligations that they are supposed to, that countries are supposed to comply with. But also, Nicolas was mentioning something that is key here, right? The other members, because the system is not about only two members. Of course, these are the major members, these are the most active, and these are the ones that rule, let's put the most of the trading system. However, these other many countries exist, and we talked about the African countries, right? Now, how they have a very important role in terms of the voting and of alliances in this case. So let's say that indeed the rule of law is in crisis in the WTO, but still there is a fora there where countries can create alliances, and there is a space that is institutionalized for discussion of different matters, right? On certain issues, and when many countries are involved. For example, a few hours ago, China and the U.S. again, they met together, and it wasn't in Geneva, right? And like to find another agreement. So I mean, it's relevant, of course, and the rules are still there. But of course, we agree that yeah, it has failed in many areas. However, when there is not an FTA, then there is where it provides a little bit of certainty, at least when the goods cross borders, right? So there is something that exists and that they have to impose, right? Like a tariff that can be imposed, and there is like a little bit of or there is a regulation there, and it's about the MFN tariffs, right? So another thing that you mentioned, Alvin, is like how can you I mean, how can countries be influenced, right? Like by taking decisions. And I think there is clear that we mentioned, like, okay, that there is a space for alliances for other countries that are not US and China, but also for US and China, at a domestic level, their industries they play a very important role, and for example, to actually be heard. So now we are back to, and there's a very interesting post that Jost Pauling mentioned, that now the dynamics have shifted, and now rather than listening Geneva, now Geneva listens to the countries, right, to the national interests. So here the industries, the lobbyists play a very important role, to the extent, let me give you an example. When in the first era of Trump, when he was about to withdraw from the USMCA, at that time, it was 2016, then the dairy industry had a meeting with him, showing him the importance that it was, how important it was to keep having a USMCA, right? And it really stopped him from withdrawing, right? Also, the automotive industry have pushed a lot for not increasing certain tariffs, okay? In the case of Mexico or Canada, also there are other industries that have pushed as well. So I think this is also the way on how industries can play a different role, and not only, and other stakeholders are taking a pivotal role in this trade arena. Thank you.
Thank you both. I think, Alvin, your third point was focusing on regionalism, right? So just maybe I will ask us just to wait a little bit before we get there, because at least I was curious, I mean, to hear from our speakers about their perspective on some of the factors that are related to the trading system, to the WTO setup, that kind of underlie or maybe reflect this movement that was referred. I mean, the U.S. Is done with the WTO, right? We've heard it from our speakers, and then we have other countries that are still in the process of either not being patient enough to wait for it, or battling for the possibility of engaging among themselves, still trying to stick to what the system, I mean, would invite to, and this is maybe to their own favor, right? Not for the sake of the system itself, but for the sake of each country's own interests. But so if we still focus on this system a little bit, the multilateral trading system, could you address some of the factors that kind of have led to the situation where we are today, where countries seem to essentially maybe care less than they have in the past?
Yes, absolutely. I think we need to look at 4 factors. One is the failure to negotiate to conclude the Doha round. The one is the dispute settlement crisis. Another one is the rise of China and the success of Chinese industrial policy. And the fourth one is the rise of security concerns in international economic relations. So just quickly on each of those. So if we look back to the Doha round, the United States effectively abandoned the Doha round in December 2015 when they said they would give up. And what had become clear at that point was that they would not be able to achieve in the Doha round any significant additional discipline on the emerging economies. And that was particularly China. It was, of course, in Brazil and India as well. And why was that? Well, one reason was that the starting points were so different. So the United States and European Union already have very low bound tariff, which means in the WTO that they have very little negotiating currency. And so under the principle of special and differential treatment, which allows developing countries to make fewer concessions than developed countries, the Doha round would actually have made the problem worse, because the developed countries would have had reduced their tariffs even further from very low levels already, whereas the developed and emerging economies would have reduced their tariffs by less due to the principle of special and differential treatment. So the developed countries really put their hope in so-called sectoral agreements, where they would, in certain sectors in which China and India and Brazil were competitive, would all reduce the tariffs to zero, just to bring, as they put it, to allow the emerging economies to catch up with the low tariffs of the developed countries. And that was simply rejected by the emerging economies on the basis that they would be making disproportionate efforts if they went down to zero from their very high tariffs. So it was a fair point, but it was a structural issue that was faced there. The last-ditch attempt that the United States made was to obtain additional disciplines on Chinese agricultural subsidies. That also failed. And so I think from the US and EU perspective, when it became clear that the Doha round would not lead to a harmonization of discipline between developed and developing countries, and particularly the emerging economies, it became pointless. And it was also, at that point, impossible, for example, probably to achieve consent to the Doha round domestically. Because if you have no significant additional market access that you can offer your industries, why would industries support such an agreement? Right? So I think the failure of the Doha round, which was due to these structural imbalances between the United States and the EU on one hand and the emerging economies on the other hand, is a big factor. I already mentioned briefly the settlement crisis, which was due to the interpretations adopted by the appellate body, which the United States felt, with, I think, some justification, were not based on the original understanding of the treaty parties. But the more important point, I think, for the point where we are at now is just the incredible success of Chinese industrial policy, right? Because we hear Trump talk about the trade deficit all the time. We hear them talk about the loss of manufacturing jobs, this China shock. And that's something that other developed countries are also grappling with. China has just been successful in building up industries in a way that nobody would have imagined in even 10 years ago, or even let alone in 2001. So the United Nations Industrial Development Organization projects that by 2030, China will account for 45% of industrial production worldwide. And what does that mean? Well, it means that the old world, where we essentially allowed companies to build the division of labor based on efficiencies and based on what they thought were best, and we would simply kind of set the rules, countries simply set the rules, and companies kind of competed in the market. For many developed countries, that is no longer a plausible world, because if we let that happen, China will just dominate everything, all industrial production, and other countries will lose their industrial sectors. And so what that means is that we have to somehow intervene more aggressive, like developed country governments have to intervene more aggressively. And for many years, they did that through trade remedy investigations, imposing high anti-dumping and countervailing duties and safeguards. But in the first Trump administration, judged that that was not enough, that had to do more to kind of counteract what it sees as non-market practices by China. And it probably goes too far to discuss the Chinese economic model. That would be another subject for another seminar. But I think we have to recognize that the concerns are real, and that that China has just is achieving a position of dominance in so many industries that many developed countries' governments feel the need to react. And I just want to point out here that the Canadian government has also imposed a 100% tariff on electric vehicles from China. And the final point that puts pressure on the system is the rise of the perception of international economic relationships through a security lens. Like we have simply, we thought, or the GATT was built on this idea that the more international independence we have, the more peaceful we're going to be, because we're going to be dependent on each other, so we won't want to fight each other. And now in the past couple of years, we have realized that this interdependence can also be weaponized. And we're seeing that right now between the United States and China to an unprecedented degree, where the United States is imposing export restrictions on semiconductors, on aircraft parts, on all kinds of things that China needs. And China is imposing all kinds of export restrictions on rare minerals, rare earths, and other critical minerals that the United States needs. And so interdependence is suddenly no longer seen as something that will promote peace. It's seen as something that will make you vulnerable. And so countries then use the security exceptions to essentially say, we need to have our own production in this area, or we need to deny access to certain materials to our competitors. And to the extent the security exception has, of course, always been there in the GATT and the other WTO agreements. But to the extent that ever more trade actions are covered by that exceptions, the rules, of course, lose some significance, because the exception covers ever more trade, and the rules lose traction. So I think it's those four developments that have led us to this point, and none of them can be easily dismissed as a fantasy. They're all real concerns, and even if one doesn't support the way the Trump administration is addressing them, which I certainly don't, we have to recognize that they pose fundamental challenges for the trade regime that all WTO members have to pay attention to.
Thank you. I think that was very organized. So thank you for that too. And Professor Ramirez-Robles.
I think it is so powerful, this last phrase that you said, Nicolas. Interdependence will make you vulnerable, right? Rather than bringing peace, that this was the speech and the principle on why the system was created as it was created, right? So it is indeed very, very, all of a sudden, I mean, as soon as the US started losing cases, then he didn't like the system, right? So, and this is now the biggest threat, for example, at the investment disputes, that it's also the national security issue is there. It can come as well, like as latent as in the trade arena. And then what is funny is, what is very interesting is the way that the U.S. structure it, right, in its own system. For example, there is this Committee on Foreign Investment in the U.S., right? This CFIUS that is used as the committee to actually justify what threats the national security of the United States, right? So, and then also there is this other act that has created that justifies as well, I mean, these national security issues as the International Emergency Economic Powers Act, the overarching and the reciprocal, right? So it looks as if it's a policy objective, the way that they have structured it, so, and that is coherent with their policy objective, so they can not, so this is allowed for them to exempt their obligations under the WTO. So now it has, rather than focusing on building these global value chains, has been like destroying the global value chains, just focusing on the internal policy in order to try to reach the achievements that China has achieved, but other with a strong, let's put it this way, legal justification, if you want to see it that way, right? Or at least some structure there. So it's now it has just with the objective of focusing on developing its industrial policy. So yes, I think also it's important to highlight that where these institutional challenges have they come from, right? They come from weaknesses that exist in the system, so that they have existed from ever since it was created, but that also exist in many other systems, because once again, this is about countries can only agree in certain obligations if they have this policy space, and that's why they leave these constructive that now is this destructive policy space, right, in the system. So one of the things that we know that has been tremendously that hasn't helped the WTO is this consensus, the consensus rule, and in so many, for the key and main issues, right? So this hasn't allowed us to update into many other agreements that are very significant to the reality right now, and that has stopped, the organization from evolving also substantially speaking, right, in new different subjects. So this is also that it has been used, right, as it was used, the possibility of blocking the appellate body, right, that is a structural problem there, but it was used when it was convenient, right, for the countries, as it was convenient in the GATT times when they blocked the panel, the adoption of the panels. So now they use this other structural weakness to block it, right? But I don't know if this latest conversations with China, now they're having the second one, it can be a hope for this this trade war to stop, at least, because they know that interdependence then is key for them. So this is when I think it is very, for developing countries, this is absolutely true, that in their interdependence make them vulnerable, but I don't know if and we see it, that is for China and the US, because of this interdependence, is that they are in conversations, right? So it can play a double role, I should say. So, for countries that do have the possibility of negotiating and the importance, either from their materials, like the raw materials, or from the consumers, right, that the US provides, or China as well provides. Thank you.
Okay, so before we move to, I think, Alvin's point on regionalism, and I want to give the floor to him as well on that. Just to note a comment from our audience, which, it kind of, Daniel Mulis, it's another institutional factor, but more of a reflex maybe, that he says that the WTO has had its operations affected also because the US would presently not be funding the organization. So that's another, I think, structural kind of a factor of the system. Maybe we can call it a weakness, right? That it depends on funding from members, and there's this funding issue as well that he raises. So thank you for your comment, Daniel. So we've covered, I think, questions 1 and 2 from Alvin, right? So Alvin, can you remind us of your third point, and maybe you can join in also the discussion in that one?
Okay, so maybe before I go to the third point, so when you're talking about the institutional factors, and as I've been rightly pointed out, especially by Professor Nicolas, I think there's also another point to look at it from the point of there's a perspective of these concerns have been shared concerns by members. It just happens that the US was the bold enough country to now act on it. And the rationale behind this is, for example, we've now seen some members moving in to have the MPIA in place. And when you look at some of the concerns that the US was raising through the USTR reports and what the MPIA has done, especially, I'm just basing this on their first decision, that is in the Colombian frozen potatoes. And you look at the various issues that the US was raising, and you can compare it. It's almost a checklist at what the MPA was doing. The decision was shorter. It wasn't a long decision. It was a shorter decision. It took less time. And at the end of it, the parties involved were all agreed, and there wasn't anything in relation to either that the the body overextended their mandate or didn't really uphold the rights of the parties. So perhaps there is also a perspective where these concerns that the US is sharing, they are not just common, or they're not just unique to the US. There are concerns that members have shared. It happens that the US was bold enough to take the action that they did, but now also other members are finding ways, as Professor Ramirez has said, realizing that it's all an interdependence, and even more or less like more than ever, we need the rules in place. But so just moving into now the other part of the conversation, which was in relation to this aspect of now the multilateral trade system is, it's being shaken to its core. And more than ever, we are seeing the rise of FTAs, free trade agreements, and and economic partnership agreements between the EU and some countries, the UK and some countries, the US, China. And so now the question is, then what happens to the concept that we've come to understand of global value chains, and how does this affect now the regional aspects, such as one region knowing for us we are good enough in producing these particular products, and now in the global scale is we are all contributing towards a common goal. So perhaps Professor Nicolas, you can weigh in on that, as well as Professor Ramirez, on now what's next in as far as the value chains are concerned and the regional aspect.
So on that point specifically, I think that the US-China competition is, of course, highly worrying for many countries because of the impact it has on the trade regime. But it also presents opportunities, right? It presents opportunities in two ways. One is that China and the West are kind of competing for the allegiance of developing countries, and they are therefore going to be more deferential to their wishes. So, for example, take Indonesia as an example. Indonesia has implemented export restrictions on nickel as part of its industrial strategy, which are clearly WTO inconsistent. But what we're seeing is that the EU is taking, which has brought a case against Indonesia and won at the panel level, is taking a much more cautious approach in trying to enforce or in trying to pursue this issue than it might have done 10 or 15 years ago, when it might have been very aggressive. And I think underlying that is, on the one hand, a recognition of some of Indonesia's legitimate interests, but also the awareness that if the EU or the West were to push too hard, Indonesia would just go further into the Chinese camp, so to speak, right? So Indonesia now has options. And that, of course, applies to other countries as well. Like if you feel too much pressure from the US or the EU, you just go with China. If you're unhappy with China, you appeal to the US and the EU. So there's some freedom of action. I think that actually, ironically, arises for developing countries from this situation. And the second point is much more concrete about particular goods. That, of course, when we're looking to the critical minerals where China has this chokehold, many of those are in developing countries. And so if the European Union or the United States want to diversify their sources of imports, they will have to look to these developing countries in order to make sure that the minerals come from those countries directly into the EU and the US, rather than going through China for processing. And so again, I think there are signs that both the US and the United States recognize that they have to make it attractive for developing countries to do business directly with the United States and the EU. They have to not offer just trade agreements and rules, but also investment and financing in order to support developing countries. And so there's a real opportunity, I think, here for developing mineral-rich or commodity-rich developing countries to drive a harder bargain in the negotiations with the United States and the EU. And so I'm not sure that trade agreements, formal free trade agreements, are really the way to go here. I think the model that is being pursued, which may be more promising, are these partnership agreements or framework agreements, which combine some trade rules, but also investment and financing, right? So that you don't just get the rules, you also get like essentially subsidies or guaranteed financing, preferential financing, in order to make the investment happen in developing countries. And I think that's, if I was advising developing country governments, it would be not to just look to formal agreements, but rather to try to make sure that developed countries step up and match some of the things that China has to offer. I mean, some of the things that China offers developing countries is preferable, right? There are no lectures on human rights and other governance requirements that come with China. But often the terms are not that great, right? Often China sends its own workers, or it has higher interest rates than you might be able to get from Western sources. So I would look at this as an opportunity for developing countries to essentially play off, if you want to put it crudely, play off the West and China off against each other to see where they can get the best deal.
Professor Ramirez-Robles, may I ask you to kind of maybe try to address the question from a somewhat different angle, to the point of tariffs and tariff wars? You are speaking from a US MCA member country, right, or party. Could you discuss maybe the influence that the agreement has had on the different tariff measures that the US has recently adopted? So we have kind of a little case on point here.
Yes, which is not minor, right? Now we cannot untangle multilateralism and regionalism. I mean, now everything comes together. The negotiating arena has become more robust. It's not about only trade, but it's about, like in the case of USMCA, for example, they bring all together, right? Like migration, labor issues, they bring environmental issues. So it's about bringing everything that is convenient for the ruling party, but also, like Nicolas said, like China plays a key role, but Mexico could take advantage of in certain areas, but it's dangerous also to be to play a lot with China if you are a neighboring country that where your economy depends more than 90% of your neighbor country, right? So let's say that the USMCA is a space for countries to for the three countries to justify certain dialogue, but it's also a place where, well, let's put, like, for example, now with the tariffs war, right? So apparently, well, the Trump administration wasn't that aggressive with Canada and Mexico, just because they were part of the USMCA, right? So this was like apparently, but then let's don't forget that there is a renegotiation of the USMCA in this in 2026, and there is where conditions will come, right? And this is, and they use the U.S. has been aggressive in this sense, and very determinant on the sense of saying, like, if we don't do what I'm saying, then I'll be out of this FTA. So it is a very difficult situation. I cannot even say that it's a love and hate. It's just something that has been very brutal. Like the policies, the threats. Mexico hasn't reacted that much, and smartly so, because it is a difficult way of handling this situation, right? How it has been affected, obviously, the global value chains have come that in the most of the products in the market are dependent on in one way or another, and from U.S. from the chain with the US, from a chain with the US, and that is what has become a very fertile land for a conflicts, right? So Mexicans have played a role that hasn't been passive, but they have collaborated and they have cooperated a lot, and they have promoted the dialogue, right? And so, but it hasn't been an easy situation. I think Canada is better placed, but perhaps Nicolas can give us an idea on how the things are working there.
If I may add just a few words on USMCA, I mean, yes, three things have happened. One is that the USMCA has suddenly become much more valuable, because before we had the USMCA, many Canadian exporters, for example, could export to the United States duty-free. Before the tariff war, many Canadian exporters could export to the United States duty-free, even if they didn't show that they were USMCA compliant, right? Because simply the US tariffs on many industrial goods were zero anyway at the MFN tariffs, right? And so the preference margin, the gain that you would get by complying with the USMCA wasn't that great. Even in the case of cars, which is the biggest manufactured export, the US MFN tariff was 2.5%. So manufacturers in Mexico or Canada could always choose not to comply with the USMCA rules of origin and simply export to the United States with paying the 2.5% tariff. Now, when Trump came in with a 25% tariff on all Canadian and Mexican goods, he then exempted USMCA or CUSMA compliant goods from that, and suddenly the preference margin is huge. If you comply with CUSMA, in some cases you pay a 0% tariff still. If you don't, you have to pay a 25% tariff. So suddenly the agreement has become incredibly valuable, and many Canadian exporters are scrambling to comply and satisfy the rules of origin in order to take advantage of it. So that's kind of the positive story about the USMCA. But the larger story is much more negative, because under the first Trump administration, the approach that the Trump administration took was a Fortress North America approach, right? So the USMCA compared to NAFTA kind of raised the boundaries towards other countries. The regional content requirement went up from 62% to 75%. But there was a sense that the Trump administration was trying to build North American supply chains. That's no longer the case. The Trump administration now wants to build US supply chains. And so that is reflected in the fact that the 25% tariff on cars, the 50% tariff now on steel and aluminum, they also apply, with some exceptions, to Canada and Mexico. And the US has made it clear it doesn't want cars made in Mexico and in Canada to come into the United States. It wants to reshore all the production. And that has had an incredibly chilling effect on investment in Mexico and Canada. So some companies, some car factories in Canada have reduced shifts, some that had been closed for retooling. There's really questions whether they're going to be reopened. Investments have been suspended, which probably means canceled. And so this is really no longer a regional or Fortress North America approach. That's the Fortress United States approach, Fortress USA approach. And so when we think about the renegotiation, it isn't even clear on which basis we would negotiate with the United States, given that their objective is to bring all the manufacturing back to the US. And so this hope that Canada had that we would be part of this Fortress North America with Mexico and the United States, it's really it's no longer clear that that is still justified. In fact, if the economic reality wasn't as stark as it is with North American supply chains as integrated as they are, so it's very difficult for US car manufacturers to shift all the production to the United States. It'll take years, it'll take billions of investment. We would probably already not be exporting cars to the United States, right? So it's regionalism in the case of a Trump administration that is as protectionist as it is not a solution. It hasn't been saving Canada. It won't be saving Canada or Mexico from the impact of these tariffs.
Thank you. Alvin, yeah, please.
Also, I just wanted to add something on what Professor Nicolas said, started by saying when you're talking about the global value chain on the freedom of action. And yes, on one hand, it does bring perspective. For example, when you talk about Indonesia as a player in nickel and having the freedom of choice, but then also there's some aspects to be considered. For example, just bringing the conversation to Africa. I mean, Kenya exports to the US apparels. I mean, coffee and tea, they're also one of the exports. So then if we say freedom of action, and now because of the tariffs, Kenya has as a value chain player, it has the option. The question is, but is China as a player also, does China need the Kenyan coffee? Does China need the Kenyan apparels? So those are some of the questions that members have to grapple with. And so in the grand scheme of things, it is the market factor itself here comes in, because we are not just talking about a market being directly substitutable because I cannot take here, I can bring it here. There's also the market factor in terms of before, for example, the Canadian, vehicles, before then, where if Kenya was to say maybe now that Canada cannot export to US, it's exporting to Kenya. Where was Kenya getting their vehicles before? They still had a market there. And then in that point of view, if Canada was to at the same time become also a player here in this market, then where they used to get vehicles before, it is still going to destabilize the market. So the whole point is the freedom of action is not really as straightforward, because it is not something that you replace from one place to another, because that market itself, as we started by saying, trade is predicated on it being predictable and stable. So this is how it was predictable. And now forcing it to change has a ripple effect on almost all the industries. And so the freedom of action, yes, has some merit to it, but then on the downside, the negatives to it are much more detrimental to the market. And that's why the whole retaliatory measures, it's really affecting the market, in my opinion.
Thank you so much, Alvin. Thank you to our speakers so far. I think we can open the floor. We have 14 minutes left in my count. Would anybody like to ask questions? Just raise your hands and we will unmute you. Okay, we have Deborah Bryan.
Hello. Hi.
Hi,
Good
Deborah.
morning. I think you kind of addressed this implicitly, but I just wanted to directly ask if you think that this trade war is likely to threaten the existence of WTO, or if you think that these rules that we have now are likely to fall apart if countries continue to violate fundamental principles like MFN and Article 2, and even continue to ignore the dispute settlement understanding, like eventually, like perhaps years to come. What do you see?
Thank you, Deborah. Maybe I'll ask who would like to take this one.
I can go first. I don't think it will threaten the existence of the WTO, because we first have to keep in mind the United States is one member among, I think it's now 166 members. And of course, it's a very important one, but I don't think we see widespread disregard of WTO rules apart from the United States and countries responding to the United States. That would be more worrying if other countries started disregarding their WTO obligations towards each other. I think it's very understandable that countries are disregarding their WTO obligations vis-a-vis the United States, because otherwise you would be kind of fighting with one hand tied behind your back, right? So there's a sense that the United States is trying to regain negotiating leverage through the tariffs that it's imposed, and other countries are imposing retaliatory tariffs, those that are, in order to nullify that gain in negotiating leverage, right? In order to not allow the United States to gain an advantage by acting illegally. And so in some ways, you could even say that other countries retaliating against the United States preserves the system, because it prevents the United States from gaining an unfair advantage in the system, right? It just neutralizes any advantage that the United States is trying to get by acting illegally. So that's the first point. I think we will have to be concerned about the WTO if countries are acting disregarding the obligations towards each other on a widespread basis rather than just vis-a-vis the United States. On the dispute settlement understanding, we still have the MPIA, the multi-party interim appeal arbitration arrangement, and we have new members acceding to it. And so there seems to be a recognition that it is a useful tool. And crucially, we have some of the biggest trading relationships, for example, between the EU and China, between the EU and Japan, between China and Japan, now kind of covered by the MPIA, because those WTO members are parties to the MPIA. And so we often, I think we have to keep in mind, despite all the noise generated by the Trump administration, that it's really just one player who is, of course, a big player, but it represents a bit of an odd one out in the WTO, right? And the other big players, China, the EU, Japan, still very much support the system and try to use it in their trading relationships with each other. And so I don't think this trade war will be the end of the WTO. Of course, it presents incredible strain. Not having the US part of the system is a huge loss. Although, and again, what I hear when I go to Geneva is that at the working level, the US is still present. They still present submissions. They don't bring disputes, but they're still there. And I think the sense that I get is that at the technical level, to the extent that US officials are allowed to operate, they are kind of staying involved in order to be ready for a day, perhaps, when the US is willing to re-engage.
Yes, and don't forget that the WTO is still a forum that brings or that provides transparency, right? So this is the only forum where countries, and is the majority of the countries of the world, that bring that notify like the changes that exist at a national level, right? So this allows them to monitor as well. And let's don't forget that there exists this TPR, the trade policy reviews, that also bring like a scope of where the countries are, and then let the basic core of the WTO, the tariff bindings, right? So for those countries that do not have FTAs among them, they still have the tariff bindings there. And also, of course, at a very different way, we will not see like agreements as they existed in the past, but we will see initiatives. So initiatives for specific topics. You will see efforts as well, like Nicolas mentioned the MPIA. The MPIA was a tremendously valuable effort for countries. In the meantime, that the DSU reforms reaches any outcome, right? So, and there are also this investment facilitation area, and these type of efforts play and have an impact at a domestic level. Okay, so like as I mentioned before, the trade facilitation agreement. The trade facilitation agreement has provided a different framework for at a national level for many different countries that haven't been and this is derived from the WTO, right? So as is derived the e-commerce initiatives, and so there a lot of things. It's a robust organization that will keep alive in certain areas, although of course it doesn't, it has, these trade wars have come to end the rule of law, and have that existed at the WTO from the dispute settlement side, but it exists also. There are other areas that are still and will still work.
Thank you, Deborah, for the question. I think I used the word existential threat at the beginning, right? Maybe that was not so huge of an exaggeration to think. I think the WTO is under an existential threat moment to the extent that it has to find a way to remain relevant. I'm not sure it's yet found that way. That's only my view. I think it's the system. There's many initiatives in place. Some members are trying to keep it up, but there's, I think, this still need for the system to find itself how to operate in this new scheme of things, even if only for the present, right? Because we're not sure whether what's happening now will remain as kind of the main uh, 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 trend, right, going forward. Although I think what we see today is kind of an extreme version of what has been happening in the past several years, right, or few decades, 2 decades maybe. And I think our speakers address that evolution in their engagement with us today. Okay, I see Professor Lamp. Yeah, please.
I just want to push back a little bit against that, because I like to compare it when I speak to my students to the criminal law. We wouldn't say that just because we haven't been able to adopt a reform of the criminal law in several years, the criminal law is no longer relevant. It's still there, providing the background rules. And the question is always, I mean, even Robert Lighthizer said at one point, if we didn't have the WTO, we would have to invent it. Like all the elements of the system that are working on a day-to-day basis, like the tariff bindings, the way you do technical regulations, the notifications. I just don't see countries stopping to do that just because one significant player is violating a significant part of the obligations, which is the United States. And so I just don't see how the fact that that is happening means that the body of rules that is in place and that has been providing the backbone of the global economy for 30 years, how that is suddenly irrelevant just because we see these conspicuous instances of non-compliance. And so I would simply, maybe we have to, yes, the WTO is not negotiating new rules, and so it's not keeping up. Yeah, the rules are staying out of date. But I encourage students to think of it as providing this backbone to international economic relations in a similar way that the criminal law does in a domestic setting. And just because you have one rogue actor doesn't mean that it all becomes irrelevant. Anyway, just a counterpoint.
Yeah, no, I think we're almost there. It's just a slight difference in tone, maybe, but we agree with 90% of what, at least I agree with 95, maybe even more percent of what you just put. So that having been said, I think to the extent that we see a system functioning and relevant, but facing some threats and rogue actor, as Professor Lamp put it, it's also good for us as students, academics, practitioners to consider, right, what to make of this system today and then going forward. I'm sure at TradeLab we will have, and we do have a lot of interesting projects dealing with different aspects of that system. I think everyone is a little, I think, overwhelmed about the speed, as I said, and the intensity at which trade-related discussions have taken place through tweets, through the press, through, I mean, webinars like this in Geneva and in all over the world from a domestic perspective. The mission of TradeLab, I think sort of that's the raw material, right, for TradeLab as a network of clinics. So we would like to, again, emphasize that we are ready to receive your projects as potential beneficiaries, right? Our students are ready to take them as students. I see Genevieve Remy is there, so maybe I'll let her say goodbye to us. At least from my perspective, this was very interesting. I wanted to thank our speakers, Professor Ramirez-Robles, Professor Lamp, uh, uh, and then my fellow commentator, moderator, Alvin Kubasu. Thank you very much for joining us. Thank you all for the audience. And we will, I think, after this one, think of other sessions like this where we can reunite again and talk about those very interesting and pressing issues of the moment. Genevieve, anything?
I didn't plan to jump in at the end. You did such a wonderful, marvelous job. I think usually the sign of a good webinar is that even at the end, especially for 1.5 hour session of, difficult concepts and applying them to what's happening, you still have most of the people staying on. So well done, Luis. I think you handled the moderating very well. Let me just also, on behalf of TradeLab, thank our brave speaker, a student, Alvin. Thank you so much for demonstrating how bright our TradeLab students are. But of course, let me thank in particular Nicolas and Edna, supervisors of their respective clinics. And really thank you all for taking the time to do some real hard work investigation into the legal concepts, because I think there's so much happening in the sphere of trade, tariffs, and war that I think just to have some time to sit back and think about it from a legal perspective and understand how this squares with the rules at the WTO, and separate the fact from the fiction, but also engage in a discussion at the level at which people can really realize how important it is to understand what's going on under the hood, was really, really wonderful. And it demonstrates with you and the student, it demonstrates the real value of TradeLab, which is having the supervisors and the students working for good in the trade system. So thank you, Luis, Edna, Nicolas, and Alvin. And before I close, let me thank so much Saloni Shukla, our TradeLab coordinator, for putting all of this together behind the scenes. And you've done a wonderful job in ensuring that we managed to get through this smoothly. But last but not least, the students, audience members who have logged in and keep supporting TradeLab. Give us your feedback. Tell us what you thought about this first event. As I said, it's the first event TradeLab has hosted, which is kind of open to the public, and we would really like to hear your thoughts on TradeLab. So on behalf of, again, Catherine Coleman, the co-president, and myself, let me thank everyone for being part of this first TradeLab goes to the public. And we would really like to encourage you to continue supporting the TradeLab network and ask us to host any of your projects that, as Luis was saying, where you need assistance on issues relating to international trade and investment law. If our students and the TradeLab clinic near you can assist, please get in touch with Saloni, and we will try, or the supervisors, and we will try to assist you in coming up with answers to some of the issues you face. So thank you all so much, and enjoy the rest of your afternoon or morning or evening. All the best, everyone. Goodbye. Thank you.